Subscribe to our channel and press the bell icon so that you never miss any video lesson from Rao's IAS Study Circle. Join the official Telegram channel of Rao's IAS Study Circle to stay updated and get all the materials on the Telegram. The link to the channel can be found in the description box. Hello and welcome to Daily News Simplified, an answer to what, why and how of newspaper reading from the UPSC Civil Services examination perspective. Now today let us take up the New Delhi edition of the Hindu newspaper dated 30th of May 2022. These are the list of the news which we will be taking up for today's discussion, and timestamping for these has been provided in the YouTube description. So on this note, let's start our today's discussion from our prelims and mains point of view. Now the first news to be taken up appears as an editorial on page number 6. Now this editorial says that India needs a law to make compensation for unlawful arrest as a statutory right. Now this editorial mentions about the shoddy investigation which was conducted by the Narcotics Control Bureau with respect to arrest of Aryan Khan, and now because of lack of evidence, Mr. Aryan Khan has been released. So on this note, this editorial highlights the need for a law to make compensation for unlawful arrest as a statutory right. So this article says that the government needs to come up with a legal framework for such people who are jailed without proof, and also there is a need for a proper compensation mechanism in case of malicious prosecution. As of now, the Criminal Procedure Code does provide for the provision for compensation, but that is not enough, as the CRPC provides for a small fine which is to be imposed on such person on whose complaint another person is arrested without sufficient grounds. Now since the person is arrested without sufficient grounds, hence because of lack of evidence, they are compelled to be released. So it is in this regard this editorial mentions about need for a proper legal framework for such people who are jailed without proof and have to stay in jail as the prosecution fails to gather evidence against such accused. Now from our examination perspective, this editorial highlights about the Narcotics Control Bureau, and here we need to know about the functions of Narcotics Control Bureau and also other institutions. So on this note, before starting our discussion, let's go through these practice questions. So the first practice question says, supervision of cultivation of opium poppy in India along with providing license to the farmers for its cultivation is done by. Options are Department of Revenue, B. Narcotics Control Bureau, C. Central Bureau of Narcotics, and D. Ministry of Health and Family Welfare. Now the second question says, consider the following statements about Narcotics Control Bureau, that is NCB. First, it is a statutory body. Second, it functions under Ministry of Finance. And third, it liaisons with Interpol to gather intelligence on drug trafficking. And the third practice question says, consider the following statements. The Narcotics, Drug and Psychotropic Substances Act 1985 was framed based on India's international obligation under UN Drug Convention as well as Article 47 of the Indian Constitution. And second statement says the NDPS Act 1985 is administered by Ministry of Finance, Department of Revenue. So in this, the question was which of the statements given above are correct. So based on these MCQ, let us understand about the narcotic, drugs and psychotropic substances, what has been provided under Article 47 of the Indian Constitution, which is a part of Directive Principles of State Policy, and also various international conventions against drug trafficking which India has signed and ratified. So Article 47 of the Indian Constitution, which forms part of Directive Principles, mentions about the duty of the state to raise level of nutrition and standard of living and also to improve public health. So it says that the state shall regard the raising of the level of nutrition and standard of living of its people and improvement of public health as among its primary duties. And in particular, the state shall endeavor to bring about prohibition of consumption except for medicinal purposes of intoxicating drinks and of drugs which are injurious to health. So based on Article 47 of the Indian Constitution, which forms a part of DPSP, the Government of India has legislated the Drugs and Cosmetics Act, the Narcotic Drugs and Psychotropic Substances Act 1985, and also Prevention of Illicit Traffic in Narcotics, Drugs and Psychotropic Substances Act of 1988. And also based on Article 47 of the Indian Constitution, the Government of India has come up with a national policy on narcotic drugs and psychotropic substances. So the Government of India has enacted these three legislations along with the national policy on narcotic drugs and psychotropic substances, as India has signed and ratified these three international agreements. These are Single Convention on Narcotics Drugs 1961, Convention on Psychotropic Substances 1971, and the UN Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substances 1988. Now, another important information for you is that the responsibility of drug abuse control is carried out through a number of ministries, departments and organizations. And these also includes Department of Revenue under the Ministry of Finance, as it has the nodal coordination role as the administrator of Narcotics, Drug and Psychotropic Substances Act 1985, and also act as the nodal coordination agency with respect to implementation of Prevention of Illicit Traffic in Narcotics, Drug and Psychotropic Substances Act of 1988 also. And according to the allocation of business rules of the Government of India, the NDPS Act is administered by the Ministry of Finance, Department of Revenue. Matters pertaining to drug demand reduction are handled by Ministry of Social Justice and Empowerment, as it also supports various NGOs and civil society organizations who are involved in drug demand reduction. Further, Ministry of Health is responsible for all health related issues and also runs several drug de-addiction centers in government hospitals. And the Narcotics Control Bureau functions under the Ministry of Home Affairs, and the Narcotics Control Bureau also coordinate actions by various central and state government agencies, including international agencies under the NDPS Act. And accordingly, the functions of NCB includes coordination among various central and state agencies engaged in drug law enforcement, assisting states to enhance their drug law enforcement efforts, collect and disseminate of intelligence with respect to drug trafficking, analysis of seizure data, study of trends and modus operandi of drug trafficking, preparation of national drug enforcement statistics in India, liaison with international agencies such as United Nations Drug Control Program, International Narcotics Control Board, which is a quasi-judicial body established by the Single Convention on Narcotic Drugs of 1961. It also liaison with Interpol, Customs Cooperation Council, Regional Intelligence Liaison Offices, etc. And the Narcotics Control Bureau also acts as the national contact point for intelligence and investigations into various drugs trafficking cases. So based on this, we can say that definitely the second statement is incorrect. However, the first statement is also incorrect, as NCB is not a statutory body, rather is a nodal agency of the central government. And the third statement here becomes correct, that NCB liaisons with Interpol to gather intelligence on drug trafficking. So here the correct answer becomes C, that is 3 only. The Narcotic Drugs and Psychotropic Substances Act regulates operations relating to narcotic drugs and psychotropic substances. Now, psychotropic substance means any substance which may be natural or synthetic, or any salt preparation as has been specified in the schedule of this particular legislation. So, it regulates the operations relating to narcotic drugs and psychotropic substances. It also provides for forfeiture of property derived from or used in illicit traffic in narcotic drugs and psychotropic substances, and also to implement provisions of international conventions on narcotic drugs and psychotropic substances. So this is the basic purpose for which the Narcotic Drugs and Psychotropic Substances Act 1985 was legislated. Now this act regulates the cultivation of poppy opium, and in this regard it is the Central Bureau of Narcotics which provides or issues licenses to farmers to cultivate opium poppy in notified tracts in 3 states of Uttar Pradesh, Madhya Pradesh and Rajasthan. So the Central Bureau of Narcotics supervises over legal or legitimate cultivation of opium poppy in India. So if a statement comes in the examination that cultivation of opium poppy in India is prohibited by law, then such statement would be incorrect. So, the Central Bureau of Narcotics is the agency which issue licenses to farmers to cultivate opium poppy in the notified fields of Uttar Pradesh, Madhya Pradesh and Rajasthan. Further, the Bureau also investigates cases under the NDPS Act and also files complaint in the court. It also provides for action for tracing and freezing of illegally acquired property as per NDPS Act. Basically, forfeiting of property if it is derived from any illicit traffic in narcotic drugs and psychotropic substances. It also issues licenses for manufacture of synthetic narcotic drugs. It issues export authorization and also import certificate for export and import of narcotic drugs and psychotropic substances. It also issues no objection certificate for import and export of select number of precursor chemicals which is to be used in such drugs. Further, import of poppy seeds is permitted only from particular countries on production of appropriate certificate from the competent authority of such exporting countries. And the Bureau also interacts with International Narcotics Control Board, which is in Vienna, and various competent authorities of other countries to verify genuineness of the transaction prior to authorizing the shipments of such substances. So these are some of the functions of Central Bureau of Narcotics. Now, to combat illicit traffic in drugs and also to regulate the drug menace in India, the Government of India has formed National Fund for Control of Drug Abuse as per Section 7A of Narcotics, Drug and Psychotropic Substances Act of 1985. And the fund created by the central government can be utilized to combat illicit traffic in narcotic drugs, psychotropic substances or controlled substances. These funds helps to control the abuse of narcotic drugs and psychotropic substances, identify, treat and rehabilitate such addicts, prevent drug abuse in India, educate public against drug abuse, and also supply drugs to such addicts where such supply is a medical necessity. And the National Fund for Control of Drug Abuse is administered by the Department of Revenue, which functions under the Ministry of Finance. So coming to practice question number 1, it says supervision of cultivation of opium poppy in India along with providing license to the farmers for its cultivation is done by the Central Bureau of Narcotics and not the Narcotics Control Bureau. And coming to the answer of question number 3, the first and second statement both are correct. As it says, the NDPS Act was framed based on India's international obligations under the UN Drug Convention as well as Article 47 of the Indian Constitution. Yes, this is correct. And the NDPS Act is administered by Department of Revenue under Ministry of Finance. Yes, this statement is also. So here the correct answer becomes C. That is both 1 and 2. Now coming to the challenges which the government agencies face to counter the menace of drug trafficking includes easy availability of synthetic and natural drugs in the market. Now, synthetic drugs are such drugs which are made by using chemicals. So with the use of technology, making these drugs with the use of chemicals has become easier. And this has also resulted in easy availability of designer drugs. Now, designer drugs are such drugs whose chemical compositions are altered by the chemist so as to fit the legal requirements. Although these chemicals can be used as drugs as well. So easy availability of synthetic drugs and also designer drugs makes it very challenging for the drug enforcement agencies to counter this menace of drug trafficking. Now various pharmaceutical companies make number of chemicals and some of these chemicals can be used as drugs. So these chemicals which is legally made by pharmaceutical companies are smuggled across borders. Further development in the field of technology also allows companies to manufacture sophisticated synthetic drugs, and easy availability of these drugs encourages drug trafficking. Now another challenge is selling of these drugs through the darknet, as it becomes very difficult to track such transactions. Now porous drug borders of India along Pakistan, Myanmar, Afghanistan allows easy drug trafficking. And this also allows easy flow of drugs along western borders, that is the Golden Crescent, and eastern borders of India, that is along the Golden Triangle. Now if you look at this map, the Golden Crescent is formed by 3 countries, namely Iran, Pakistan and Afghanistan. And the Golden Triangle is formed by 3 countries, namely Myanmar, Thailand and Laos. So flow of drugs along the western border and also along the eastern border to Golden Crescent and through the Golden Triangle makes smuggling of drugs easier and also difficult for the drug enforcement agencies to counter. So it becomes difficult for these agencies to track the routes used for smuggling of illicit drugs. Now another problem is that in India, legal cultivation of poppy for medicinal and other purposes is allowed, and this further adds to illicit drug trafficking. Further, smuggling of drugs also takes place through containers, through ships. And overall, smuggling of drugs also poses a threat to national security, as the route which is used for drug trafficking is also used to traffic illegal arms and ammunitions. Now another problem with respect to drug trafficking is continued increased demand of drugs in the domestic market, especially by youth, and this also makes the youth of India drug addict. So these are some of the challenges which are faced by drug enforcement agencies to counter the menace of drug trafficking in India. Now this topic gets covered both under GS paper 2 and also under GS paper 3, as questions can be asked under either of these cases regarding drug trafficking or preventive mechanism for drug trafficking in India. With this, let's take up the next news for discussion. The next news to be taken up appears in the text and context section on page number 8. Now this news says reservation in public employment. Jarnail Singh judgment, authored by Justice Rohinton Nariman, indicates a critical turn in the jurisprudence of reservation. So this article highlights about the important Supreme Court judgments with respect to reservation. So it says that the jurisprudence of reservation relies on the symbolic existence of constitutionally guaranteed equality of opportunity in public employment, guaranteed under Article 16(1) of the Indian Constitution. However, Article 16(4) provides for reservation in public employment, and Article 16(4)(a), which was added through the Constitution 77th Amendment, provides for reservation in promotion. So the provision of reservation under Article 16(4), 16(4)(a), 16(4)(b) and 16(6) has been provided based on Article 46 of the Indian Constitution, which is a part of DPSP. So Article 46 mentions about promotion of educational and economic interest of scheduled caste, scheduled tribes and other weaker sections. Here the provision says that the state shall promote with special care the educational and economic interest of the weaker sections of the people, and in particular of the scheduled caste and scheduled tribes, and the state shall also protect them from social injustice and all forms of exploitation. So to implement Article 46, which is a part of DPSP, Article 16(4) was added in the Indian Constitution. Now Article 16 provides for equality of opportunity in matters of public employment. Here it highlights that there shall be equality of opportunity for all citizens in matter relating to employment or appointment to any office under the state, and no citizens on any grounds of religion, race, caste, sex, descent, place of birth, residence, or any of them shall be ineligible or discriminated against in respect of any employment or office under the state. Now Article 16(4), which is an enabling provision of the Indian Constitution, says that nothing in this article shall prevent the state, that is, state can make any provision for reservation of appointments or post in favor of any backward class of citizens which in the opinion of the state is not adequately represented in the services under the state. Now further, Article 16(4)(a), which was added by Constitution 77th Amendment, highlights that the state can make provision for reservation in matters of promotion with consequential seniority to any class or classes of post in the services under the state in favor of scheduled caste and scheduled tribe, which in the opinion of the state are not adequately represented in the services under the state. Now it was here where the Constitution 77th Amendment was challenged in the M. Nagraj judgment. Further, Article 16(4)(b) was added by Constitution 81st Amendment, and Article 16(6) with respect to economically weaker sections of the society was added through Constitution 103rd Amendment. So this article in the text and context section has highlighted in detail about the reservation policy and important Supreme Court judgments. So let's go through some of the important highlights of Mandal Commission report, how this resulted in the very famous Indra Sawhney judgment. Further, Constitution 77th Amendment, which added Article 16(4)(a), was challenged in M. Nagraj judgment, Jarnail Singh judgment, which further modified the M. Nagraj judgment, and Mukesh Kumar judgment, where it was stated by the Supreme Court that reservation is not a fundamental right and it merely provides an enabling provision. So on this note, let's go through these important highlights, as these are important for you to understand both from your prelims and mains point of view under GS paper 2. Now the report of the Mandal Commission was implemented by the government through an order of 1990 and 1991. So through these orders, the government provided 27% reservation to the other backward classes, and through a 1991 order, the reservation was to be preferred for the weaker sections among the other backward classes, and it also provided for a 10% reservation for economically backward category. Now this very aspect was challenged in the Indra Sawhney judgment, whereby the Supreme Court gave a majority verdict. Thus, based on the Mandal Commission's report, 27% reservation was provided in civil post and services under the Government of India for socially and educationally backward classes. Now this was according to the order of the government of 1990. Further, on 25th September 1991, the government issued another order according to which of the 27% reservation provided to OBCs, preference was to be given to candidates belonging to the poorer sections of the socially and educationally backward classes. So basically, even among the OBCs, two categories were created. One who were more poorer sections among the OBCs, and other section of the OBC which could be said to be better off community as compared to the poorer sections of OBC. So this was a bifurcation created through the orders of the government. Along with this, 10% reservation were to be provided or reserved for other economically backward sections who were not covered by any of the existing reservation schemes of the government. So apart from 27%, a 10% extra reservation on the basis of economic criteria. So for the first time, reservation based on economic criteria was provided by the government. So the 9-judge constitution bench formed in the Indra Sawhney judgment, the majority judgment upheld this reservation of 27% in favor of other backward classes. So 27% reservation for OBC was considered to be constitutionally valid. And the further subdivision of more backward within the backward classes who were to be given preference. So this criteria of providing preference to the poorer sections among the OBC was also held to be constitutionally valid. However, the Supreme Court struck down the reservation of 10% in favor of other economically backward categories and stated that reservation should not be provided based merely or solely on the basis of economic criteria. So this 10% reservation was declared as constitutionally invalid. So according to the judgment, it created the concept of creamy layer for the better off section. And based on this, the Supreme Court held that the advanced section among the other backward class, mainly the creamy layer, should be excluded from the list of beneficiaries or reservation. Basically, creamy layer should not be given the benefit of reservation which was provided to the other backward classes. Now regarding backwardness of a particular community, the court held that the test or requirement of social and educational backwardness cannot be applied to scheduled caste and scheduled tribes. So basically, the scheduled caste and scheduled tribes need not prove that they are backward once they are included under the presidential list as per Article 341 and 342. So the court held that scheduled caste and scheduled tribe need not have to prove their backwardness, as inclusion of their name or inclusion of their communities within the presidential list under Article 341 and 342 itself highlights that they form a backward section of the community. So the Supreme Court held that the scheduled caste and the scheduled tribes are the most backward among the backward classes, and it is therefore presumed that once they are contained in the presidential list under Article 341 or 342, then there is no question of showing backwardness of the scheduled caste and scheduled tribes all over again. Hence, they need not prove that they are backward. Now, regarding the concept of creamy layer, the Supreme Court held that the creamy layer principle should only be confined to other backward classes and should not be expanded to scheduled caste and scheduled tribe. Now, another important highlight of the judgment was that there shall be no reservation in promotions and the reservation should be confined to initial appointments only. Now, this created a problem, and because of this particular aspect of the judgment, Constitution 77th Amendment, which added Article 16(4)(a), which basically provided for reservation in promotion to scheduled caste and scheduled tribes, was challenged in M. Nagraj judgment. Now, the reason given by the Supreme Court was that reservation exists to create a level playing field, to remedy unequal starting positions, thereby removing the justification for reservation in promotion. So, Indra Sawhney judgment did not favor reservation in promotion, which was added by the Constitution 77th Amendment in the form of Article 16(4)(a). So, from Indra Sawhney, we come to M. Nagraj judgment. As we have already stated, that constitutional validity of 77th Amendment was challenged, which provided for reservation in promotion along with other amendments on backlog vacancies in reservation. Now here the Supreme Court upheld the constitutional validity. That is, it said that Constitution 77th Amendment, which provided Article 16(4)(a), is very much valid, as these provisions are merely enabling provisions. So, taking a cue from M. Nagraj judgment, the Supreme Court in the Mukesh Kumar judgment said the same thing, that reservation is an enabling provision and does not form part of fundamental right for which state can be compelled to provide reservation. Now, the M. Nagraj judgment further stated that if state government wishes to make provisions for reservation to scheduled caste and scheduled tribes in promotion, then in such case, the state has to collect quantifiable data in order to show the backwardness of the class and also inadequacy of representation of that class. Now here there are two things. So for scheduled caste and scheduled tribe to have reservation in promotion, the state government must come up with a quantifiable data. And this quantifiable data must prove or ensure that there are inadequate number of scheduled caste and scheduled tribe in a given cadre of service. So the Supreme Court in M. Nagraj judgment held that reservation in promotion can be provided under Article 16(4)(a) provided these conditions were fulfilled. So it said that the court allowed reservations in promotion for members of scheduled caste and scheduled tribes subject to the following three conditions. First, the state must collect quantifiable data to prove backwardness of the class. That is, for a particular community, the state government must provide quantifiable data to prove their backwardness. Second, the state government must prove that such communities of SC and ST are inadequately represented in that cadre of service and hence they need reservation in promotion. And third, any reservation in promotion should not impact administrative efficiency of the service according to Article 335 of the Indian Constitution. Thus, the M. Nagraj judgment upheld the constitutional validity of Constitution 77th Amendment but provided for these three criteria for providing reservation in promotion under Article 16(4)(a). Now this part was challenged in the Jarnail Singh versus Lakshmi Narayan Gupta judgment. So in this particular case, the Supreme Court confined their entire understanding based on two grounds. First, whether the state has to collect quantifiable data to show backwardness of members of SC and ST. Now this was because in the Indra Sawhney judgment, the Supreme Court has already stated that the scheduled caste and scheduled tribe are already backward and hence need not prove their backwardness again. So because of this particular judgment, the ground of contention in Jarnail Singh was that whether the state has to collect quantifiable data to show backwardness of members of scheduled caste and scheduled tribe. And second question was that can the concept of creamy layer be applied to members of scheduled caste and scheduled tribe, as this will amount to subclassification within the members of scheduled caste and scheduled tribe. Now this was also important because in the Indra Sawhney judgment, subclassification of scheduled caste and scheduled tribe was declared to be not permissible. So the Supreme Court in Jarnail Singh versus Lakshmi Narayan Gupta held that there was no need to revisit the judgment of M. Nagraj by a larger bench, that is by a 7 constitution bench. The court held that states no longer need to collect quantifiable data to prove backwardness of members of scheduled caste and scheduled tribe with respect to providing reservation in promotion. However, the court held that a state still would have to collect data to show the inadequate representation of members of scheduled caste or scheduled tribe with respect to a particular cadre of service. So the court in Jarnail Singh held that the state government need not prove backwardness of members of scheduled caste and scheduled tribe, but they have to collect data to show the inadequate representation of members of scheduled caste and scheduled tribe in a particular cadre to provide them reservation in promotion as per Article 16(4)(a). Further, the court held that principle of creamy layer can be extended to members of scheduled caste and scheduled tribe for promotions in government jobs as well. Now the court said that when a court applies this principle of creamy layer, then it does not in any manner tinker or changes the presidential list under Article 341 for scheduled caste or 342 for scheduled tribe of the Indian Constitution. And the court excluded the creamy layer from such groups or subgroups including members of scheduled caste and scheduled tribe while applying the principles of equality under Article 14 and 16 of the Constitution of India. So this is the highlight with respect to the Supreme Court judgment of Jarnail Singh versus Lakshmi Narayan Gupta. Now we have already stated that reservation is not a fundamental right, and this was categorically stated by the Supreme Court in Mukesh Kumar versus State of Uttarakhand. Here the Supreme Court held that Article 16(4) and 16(4)(a) are in the nature of enabling provision, and accordingly state government has the discretion either to provide reservation in public services under Article 16(4) or reservation in promotions under Article 16(4)(a) or not to provide such reservation. So basically, citizens cannot enforce the government through writ petition to provide them reservation, as it is not the fundamental rights of citizens. So the court held that if states wish to provide reservation in promotion, then the state has to collect quantifiable data showing inadequacy of representation of that class in public services. And even if under-representation of scheduled castes and scheduled tribes in public services is brought to the notice of the court, the state cannot be directed to provide such reservation through writ of mandamus, as it is not a fundamental right. So in Mukesh Kumar versus State of Uttarakhand, the Supreme Court effectively held that state governments is not bound to make reservation, and citizens cannot claim reservation in public services under Article 16.4 and reservation in promotion under Article 16.4a as their fundamental right, and hence the writ of mandamus cannot be invoked upon. So as a revision, we can say that Mandal Commission report provided for 27% reservation for OBC. However, the government of India added 10% reservation for economically backward category, but this aspect was declared unconstitutional in the Indra Sawhney judgment, and this aspect was declared as very much constitutional. Here, the Supreme Court also upheld the concept of creamy layer. Further, the Indra Sawhney judgment fixed the quota of reservation at 50% and held that this quota can only be breached in exceptional circumstances. And based on this understanding, the reservation provided to the Maratha community was declared as unconstitutional. Now further, in M. Nagraj judgment, the Supreme Court upheld the validity of Constitution 77th Amendment, and the M. Nagraj judgment also provided for 3 criteria for providing reservation in promotion under Article 16.4a. Now Jarnail Singh judgment held that there is no need for the state government to prove backwardness of scheduled caste and scheduled tribe, but the state government must provide data to prove their inadequacy. And in the Mukesh Kumar judgment, the Supreme Court held that reservation is not a fundamental right and it is merely an enabling provision, and the state government cannot be compelled to provide reservation in promotion through writ of mandamus or reservation under Article 16.4. Thus, this article on reservation becomes very important both from the prelims and mains perspective under GS Paper 2 with respect to polity and governance. With this, let's take up the next news for discussion. Now the next news appears as an article on page number 6. Now this news highlights about the importance of BRICS. It says building peace and prosperity with strong BRICS. The BRICS partnership is working together to walk far to build a community with a shared future for mankind. Now this article has been written by China's ambassador to India, and on this note, we must also understand various points of concerns, especially for India, which we can understand by going through this particular article, since this article represents a Chinese understanding or a Chinese philosophy with respect to BRICS. Now we all know that India and China are not in good terms, especially after the LAC incursions along Ladakh. And China does not like India's involvement either in Quad or in any other multilateral groupings which involves United States or its allies. So this article overall highlights about certain areas where all the BRICS members should come together. However, there are certain points of concerns which also has been mentioned in this article. Now the author highlights about Cold War mentality and bloc confrontation. Now here the reference is to Quad, which is also referred by China as Asian NATO. Now China sees involvement of United States, Australia and Japan through Quad as infringement of China's sovereignty and its policy, especially in the Indo-Pacific region. So according to Chinese mindset, any bloc formation poses a threat to peace and security in the region. And here an apparent reference is also to India, as India is also a member of Quad. And Quad members also participate in the Malabar naval exercise. Further, the Chinese ambassador highlights an important point where he says that seeking one's security at the expense of others will impact regional security and will create more tensions. Now here also the reference has been made towards India and its other allies, especially with respect to members of Quad and also members of AUKUS. So according to the government of China, India cannot seek only its own security at the expense of Chinese security. So any bloc formation by India, which again is a strategic autonomy for India, is viewed as a threat by China. Now, another area of concern is President Xi Jinping's Global Security Initiative. Basically, this initiative is a regional security architecture whereby China intends to cooperate with all the Asian countries. However, this global security initiative has been undertaken by China based on expansion of NATO, and its implications also lie for India-China relationship, especially after the LAC incursions along Ladakh. Now, another point of concern, not only with respect to India and China, but also among BRICS members, is the issue of mutual trust on security aspects, not only with respect to India and China, but also with respect to other countries. Now, another problem is regarding geographical separation, as members are fragmented along 4 different countries. Now, another point highlighted by the Chinese ambassador is regarding accommodating China's core interest and concerns, as China is against Western hegemonism. Now, this again becomes problematic for India because to accommodate China's core, it also impacts India's sovereignty and India's own national interest. So, going through this article, we understand the Chinese mindset and they become a point of concern, especially for the government of India. And this distrust between India and China becomes one of the challenge with respect to functioning of BRICS. Now, apart from these concerns, the article also highlights about various areas where the BRICS members can collaborate, especially with respect to the need of time. Here, the author mentions about mutual beneficial cooperation in the supply chain area, energy, food and financial resilience, cooperation with respect to COVID-19 pandemic management, as the pandemic is yet not over, according to the author. According to the author, global health governance can be leveraged by BRICS members. The BRICS Vaccine Research and Development Center will accelerate development of vaccine of public health importance. The members can establish BRICS early warning mechanism for deadly diseases so that they can be warned earlier. And there is a need to embrace global governance philosophy through consultation, joint contribution and shared benefits among the BRICS countries. So these are the common areas of interest where the BRICS countries can come together for better governance. So this article basically becomes important to understand the Chinese perspective, especially with respect to BRICS. So these points can be utilized while answering a mains examination, especially with respect to challenges pertaining to BRICS. And this topic gets covered under GS paper 2, especially with respect to international institutions and global groupings. The next news to be taken up also appears on page number 8 in the text and context section. Now, this news mentions about Azerbaijan Armenia conflict over Nagorno Karabakh Enclave. Now, you need to know about this news, especially from the perspective of location regarding world map. Now, this news says that the breakaway region in the South Caucasus has been at the center of 3 wars and multiple clashes between the two countries. However, the top leadership of both Armenia and Azerbaijan have now agreed to formulate Border Security and Delimitation Commission and start talks for a peace deal. Now, earlier Russia tried to broker a peace deal in 2020, and now the European Union has entered the fray to broker a peace deal between Armenia and Azerbaijan. Now, despite this, the skirmishes between the two members continue. So, as you can see in this map, this is Armenia, whose capital is Yerevan, and this is Azerbaijan, whose capital is Baku, and it is close to Caspian Sea. And this is the Nagorno Karabakh region. So this particular region is a landlocked region. It is mountainous and forested region and falls within the boundaries of Azerbaijan. Now, Nagorno Karabakh is also called Artsakh in Armenia. It hosts a predominantly ethnic Armenian population with an Azeri minority. And it is located in the South Caucasus region and roughly made up of modern-day Armenia, Azerbaijan and also Georgia. Now, this news also highlights about a Minsk group. Now, this group was basically created by the Organization for Security and Cooperation in Europe in early 90s and was co-chaired by Russia, United States and France. And after several rounds of war, peace talks were initiated by the Minsk group, but peace treaty could not be achieved or could not be brokered. Now, even Russia tried to broker a peace treaty between Azerbaijan and Armenia with respect to the Nagorno Karabakh region, but nothing much could be achieved. So it says that the Minsk group's proposals were continuously rejected by both Yerevan and Baku, that is Armenia and Azerbaijan. And the role of Minsk group declined during 2020 war between the two countries as other negotiating groups also entered the scene. Now these other negotiating group is the European Union, which has now emerged as a potential peace broker. But as of now, no such peace agreement has been finalized between Azerbaijan and Armenia. So from your world map perspective, you need to know about the Nagorno Karabakh region, which is a landlocked area and it lies between Azerbaijan and Armenia. So with this discussion, let's take up the question for the day. Now, based on our discussion, this becomes your practice question for the day. The question is, Global Security Initiative has been proposed by, options are A, India, B, United States of America, C, United Kingdom, and D, China. Now, coming to the answer of yesterday, the question was, consider the following statements. First, goods and service tax collection in India is not subjected to overall inflation. This statement is incorrect. Second, India is consistently receiving revenue neutral rate of indirect tax revenue. This statement is also incorrect. So the question was, which of the statements given above are correct? Hence the correct answer becomes D, that is neither 1 nor 2. With this we come to an end to today's discussion. Thank you for watching DNS.